number 22, the people of the state of New York versus Howard Powell. Counsel, give us one moment until counsel can leave.
Yes, thank you, Your Honor.
Okay, good afternoon, counsel.
Good afternoon, Your Honor. May it please the court, Kendra Hutchinson of Appellate Advocates on behalf of Mr. Powell in this matter. I would ask the court for 2 minutes rebuttal, please.
Of course.
Great, thank you. You're welcome. Your Honors, in 2012 in Badesi, this court held that in the proper case, expert testimony on false confession should be admitted. Mr. Powell's case is the proper case here.
So, counsel, do you read Badesi to basically have decided that this kind of testimony should always be let in, assuming that the expert is qualified as an expert?
Your Honor, we are making the argument here that under Badesi, certain testimony would be admissible on the papers alone, particularly in fulsome papers like those presented here in this case. Badesi itself recognized that the research shows that, quote, intellectually impaired or diagnosable psychiatric disorders or other psychological fragility would be admissible. So yes, Your Honor, I think as to a certain amount of testimony, we would ask this court to hold that yes, it would be.
Wasn't the issue in Badesi whether there should be a Frye hearing?
In that case, actually, Your Honor, the court held that it was not error to refuse a Frye hearing or to refuse to permit the expert to testify. That's in the
under the circumstances of that particular case.
Yes, Your Honor.
Because of what was being proffered as what the expert was going to say, right? So here there was a Frye hearing, okay? And so doesn't that place us in a little different position?
Certainly, Your Honor. I mean, again, our point is that we can save the taxpayer expense sometimes for these Frye hearings if the court could firmly hold that some papers would entitle you to an expert. That said,
I want to ask you also to
Sure.
compare with sort of the history of some of our other jurisprudence in various areas of expert testimony. For example, eyewitness testimony. And would you agree that even though that testimony has in certain respects been accepted for pretty long time, that it has been a gradual process tested by Frye hearings and other things to determine which aspects, which scientific principles are entitled to that recognition as being accepted as reliable in the scientific community. So why should this be any different from that?
well, it's because the court has, in other areas of the law, has admitted testimony without the need for a Frye hearing. For example, in the rape trauma syndrome, battered women syndrome, other prosecution favorable evidence, of social science areas, the court has allowed it there. And we think that there are this is a 35-year-old discipline, and there are certainly some factors which we can talk about, because Your Honor pointed to there being a Frye hearing, and I'm certainly happy to go to the factors here. But there are some factors here that are so firmly established by, this 35-year-old discipline with 60 scholars and white papers.
Yeah, but some of that from the time that they were maybe first accepted, this witness herself testified that they were no longer accepted because of the testing methods involved, right?
Is Your Honor talking about like the laboratory experiments of the alt-key paradigm and the computer crash?
Sure.
Your Honor, the court has recognized that this court has recognized that there may be controversy, or there may be earlier studies may be disallowed, and that is the fact of scientific progress. Again, People versus Taylor, which is the rape trauma syndrome case that we rely on heavily. I mean, in that case, this court acknowledged that earlier studies had been criticized, and acknowledged that and even cited the criticizing stuff, but yet still held that it was admissible. And you're right, Your Honor, the people do rely on this to undermine Dr. Redlick's testimony in this case, but in fact, it's our contention that really this goes to the weight of her testimony before the jury. It was not for the judge to be the gatekeeper and decide that he disbelieved in the science just because the DA was able to
So counsel, do you think, because I think it's suggested in your briefing, is it your position that what the judge did was apply perhaps Daubert or a different standard that's not the state standard, and that's where the judge went awry? It's a misapplication of the law?
Yes, Your Honor, actually. I think it is that the judge didn't just abuse discretion in this Frye hearing here, that actually misapplied the law as to the Frye standard, and possibly, as amicus Center for Appellate Litigation points out too, as to the relevancy standard in this case, that the judge really treated this as if this were a trial question in which it were the fact finder as to whether or not it believed the science.
Let me ask you another question.
Sure.
With respect to this question about the people's position that the Frye hearing revealed that the proposed expert's methodology was not respected in the field, was rejected, and that is a basis to then deny the testimony. I know you've responded a little bit to that. I'd like you to be a little bit more precise about why that's not enough for a judge. A judge hears someone and maybe says, well, some of those studies seem to support that, but this particular expert is talking about studies that they have done, research that they have done that is now rejected. No one accepts this. It's been highly criticized. Why wouldn't a judge be properly acting within their discretion to say, I'm troubled by this expert. Bring me another expert who doesn't have these kinds of flaws in their methodology?
Sure. Well, I mean, I think there's two sort of parts to this. There's the two laboratory studies, like in-lab studies or research paradigms that had been used in the field that were not necessarily tied to just Dr. Redlick. These had been used in the field, decades earlier, the alt key and the computer crash, those two, or the cheating paradigm, and the science had moved on. So this was not particular to Dr. Redlick, and I think you'll see the testimony from her in the Frye hearing. It is that the science may have moved on or may have not been able to be replicated as much in the field. On the other hand, the other critique that the people lob towards Dr. Redlick herself is that she had conducted a number of self-report studies. Self-reporting studies are when you interview participants and ask them to self-report their experiences. Self-report is a widely accepted, scientifically sound method of gathering data. It is the method of gathering data in nearly every social science field, as pointed out in our briefs. And this court has certainly accepted it before. And in fact, in Taylor, the court noted that these were self-report.
Are you referring now to the trial court's rejection of the validity of certain psychological principles as by comparison to hard scientific principles? In other words, social science methodology is not the same methodology that one would find in plotting a course from the Earth to the moon. We can't do that kind of research with that degree of scientific certainty. Is that what you're referring to? You're identifying that as an error of the court?
Yes, exactly, Your Honor, that the court relied so heavily on the known error rate, the fact that there was no known error rate in this particular instance.
Right. The way I understand the science is you don't get it that way. And more than that, science changes. Science is a process. It's not a guaranteed result. What I'm wondering here is, it seemed that, and I've asked both counsel to respond to this, it seems that the court may have been using the Frye hearing testimony as a way to say that the expert didn't lay a sufficient foundation for his testimony, rather than, or her testimony, I'm sorry, rather than seeking to answer the question if is our false confessions generally accepted as a valid phenomena in the relevant scientific community. It seemed that that's the question that had to be answered to satisfy Frye. If that question is then answered, then that expert should not be asked whether or not he thinks that was done here. That's the jury's job. That's not the expert's job. And I think that, so what I'm wondering is has this point been emphasized, that the desire to lay a foundation for admissibility isn't quite the same as the court's responsibilities when they got to deal with the Fry hearing?
I think I understand what you're getting at here, Your Honor, is that the judge here really,
By the way, that's good. I'm glad that somebody understands that. I'm happy with that.
well, I mean, I'm just rereading LeGrand, actually, in preparation, and I noted the requirement there that a proper foundation needs to be laid for the reception of the testimony. And so to the extent that Your Honor is getting at this really may be part of the court's problem here, is that it was applying this odd relevancy standard, some sort of personal knowledge, personal,
Right.
an ultimate opinion on whether or not
Right.
this happened.
The expert then will be encroaching on the province of the jury if they
Yes.
did that. Those
Yes.
standards are not relevant to a Fry hearing standard. It's an entirely separate issue.
Exactly, Your Honor. And to the extent that Your Honor is asking about whether this foundational testimony was there, I mean, obviously you read the trial, well, you read at least the brief recitation of the trial. Yes, this evidence went in through my client, but in addition, there was a report of Dr. Draub, a psychological forensic expert, who, noted all of the factors that my client had, his IQ in the 70s, schizophrenia, substance abuse disorders, everything.
No, I know the record, but here's the problem that I struggle with. Assuming that the court made an error in the way it handled the Fry hearing and it applied the wrong standard, why isn't this error harmless?
This error could not possibly be harmless in this case, Your Honor.
Tell us
because,
why.
Yes,
Yeah.
there were two pieces of evidence that connected my client to this. This was the confession, or the two confessions, and the identification. The confession was hotly contested. It is very rare that a defendant gets on the stand and testifies as to...
Counsel, let's talk about the defendant's trial testimony
Sure.
for a moment, right? The defendant testified, to my reading of the record, to classic coercive police misconduct tactics, physical abuse, food deprivation, and in fact, he denied he even made the second statement, that my recollection is. Why would a jury, the average juror, need this kind of expert testimony to make a determination of voluntariness under those circumstances?
No, that's a great question, Your Honor. You're right. The jury was charged with voluntariness under the traditional sense, the due process sense, because it is counterintuitive to jurors. Well, number one, I will say that my client did indeed state that he confessed for the first confession, the one in which he stated he was messed up on drugs. And so to that extent, he did do that. But it is counterintuitive to juries that someone would make a statement like that and potentially still be considered an involuntary or a confession that should not be trusted or that does not have veracity. So a jury may be properly instructed about voluntariness, but social science now shows us that there is another precept as to which they should be able to evaluate this confession.
But I guess my question is, didn't the defendant's testimony really undermine the expert's assumptions of the situational factors that were supposedly present?
Well, so you're saying that the client's testimony is a misfit, basically. It does not fit with the situational factors? I mean, I guess I would disagree at least as to the theme development sort of minimization factor that that the expert was going to testify about, because, my client literally, said that Grinder told him that he would not help him until he cooperated. He told me he wouldn't help me unless I helped him. That's the type of, this is what my client testified at trial and at the suppression hearing. That's on page, or at least as of the suppression hearing, that's on page 8314. And so that does not
That's beyond the ken of the typical juror?
I think
If some, to put themselves in his shoes and say, well, gee, if they're telling me, I'm not going to get food, I'm not going to get medication, I'm not going to be able to go home unless I confess, what do you need the expert testimony for?
Well, I think this court has held that it is beyond, that some of this can be quite counterintuitive in Badesi, that as to this the implied leniency that happens.
I thought your
during-
argument was that he was susceptible to false confession because of his limited intellectual capacity and head injury.
It certainly,
Okay, I want to get just back to one, I want to stay in this harmless error question because it's something I'm kind of struggling with here. I want to know, why you say that this is not, that there were two IDs here, and you got a confession, the DD5 form, I think it's called. That's what I understand the people to be relying on. And in response to that, I think that the defendant says the identifications were wrong, his face cannot be seen in the video, and that he had 12 missing teeth, and that the missing teeth in and of itself were never pointed out by any of the witnesses at all, and it'd be an impossible thing for them to miss. So that's the way I understand that argument being framed. What's your response? Is the proof overwhelming? If it's not, why not?
No, Your Honor, the proof here was not overwhelming.
Why not?
It was not because of, precisely as Your Honor pointed out, this was, and just to correct this was a trial with one complainant, the other one the client pled to. So there was one identification in this case. She described the robber as in his 30s, 6 foot tall. My client was in his 50s. He was 6'4". He had 12 missing teeth. You cannot see from the surveillance videos, particularly the one that is in the elevator, is completely, it's frightening, and it's very impossible to see anything about who that robber is. As for the deli one, although it is 6 minutes long, there are very, very, very brief seconds-long moments in which the robber is facing the camera from a distance away with his head facing down. It is not possible from that to make a definitive identification. And for that reason...
So what you're saying is proof, but it's not overwhelming?
Yes, absolutely, Your honor.
Hey, you know, I'm not clear on this. What teeth were missing?
I don't know off the top of my head, Your honor.
Thank you. That's
But
all
it
right.
included some
but with
front
12
teeth? Did it not include some front teeth?
I think it has to include some front teeth, but I can't tell you, Your honor, off the top of my head.
Thank you.
Yes. And I mean, speaking of this, I do want to move very, very quickly and just remind the court that there is an identification expert point as well. I'm just going to bring this up because Judge Fahey brought up the identifications here. And I would ask the court to look at that carefully too, because my client here was really hamstrung. I mean, the manifest unfairness of the two pieces of evidence that come in before the jury, and he wasn't able to contest either of them. And for that reason, and for the reasons that we state before as well, his right to present a defense was...
If I can ask you about the corroboration for one
Sure.
moment.
Yep.
I'm sorry, the expert on the witness, the accuracy of the witness ID. So I just want to be clear. Your only argument on that is that it wasn't truly corroborative, or are you also taking the position that the judge should not have looked at corroboration because it was a pre-trial motion as opposed to a motion at trial once there's actual evidence?
Okay, thanks very much for asking that question, Your Honor. I think that in our main briefing, the position that we're taking is the position that counsel took below, which was back in 2011. So our preserved position is that there was insufficient corroboration here. Amicus Innocence Project brings up an excellent point that if Your Honor is asking about it, about the problem of using corroboration in the pretrial context because it is not tested by the adversarial process. And in fact, I think this case is emblematic of it. Because what you have after trial is a confession that corroborates the identification, yet the confession is hotly contested, and we know that there are details about the confession that don't match up with the crime.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
May it please the court, Danielle O'Boyle from the Office of Melinda Katz, the District Attorney of Queens County. Turning first to this court's holding in Bedesi, that case does not and should not stand for the principle that a trial court would abuse its discretion anytime it holds a Fry hearing with respect to false confessions.
Counsel, the way I read Bedesi, very simplistic maybe, but there's two things going on in Bedesi. One is that whatever the proffered science is, it has to be related to the defendant and the interrogation, right?
Yes.
So if you come in and you say, left-handed people are more likely to give false confessions, and the defendant is right-handed, you don't need a Fry hearing. And I think that's Bedesi Part 1. Then, let's say the defendant is left-handed, you need a Fry hearing to establish the scientific validity of your proposition that left-handed people are more likely to give you a false confession, right? To me, this case is the left-handed, the right-handed, and the science is bad. There were two things that were wrong here, according to this hearing judge, the Fry hearing. So one was factual fit with this defendant in this interrogation, and two was the science. Is that right? Is that the argument?
Yes, Your Honor. There are issues here with respect to both general acceptance and relevancy. And looking at this court's decision in People versus Bedesi, it's important to look at how this case discussed People versus Lee in terms of examining the broad principles of admitting expert testimony. And the very first thing the court said is that the admissibility and the limits of expert testimony lie primarily in the sound discretion of the trial court. And the court goes on to talk about a trial court needing to determine whether the proffered expert testimony is generally accepted by the relevant scientific community. So with the general acceptance point, I think it's important to look at this court's decision in People versus LeGrand, because this analogous field of eyewitness identification experts is the closest to the science of false confessions that we're discussing here. So in that case...
So what would not be relevant? What would not be relevant in her testimony?
Several of the dispositional and situational factors that Dr. Redlich discussed...
Doesn't that go to the scope of the testimony, not the full stop preclusion?
It goes to both, Your Honor, and it's important that in Bedesi, the court said that the proffered expert testimony on false confessions needs to be relevant to both the defendant and the interrogation. So it's not enough that this defendant had a history of mental illness, substance abuse, and low cognitive abilities. The court also had to look at what were the circumstances under which this particular defendant confessed. And throughout his suppression hearing testimony and trial, the defendant maintained that he gave that written statement. He never admitted to giving the oral statements. He says he gave that written statement so that the detective would provide him with his medication, which he was withholding. And to Judge DiFiore's point earlier, that really wasn't within the scope of what this proffered expert, Dr. Redlich, was proposing to testify to. So that's why this case would be similar.
I'm sorry, I don't understand that leap that you just went through. They put into evidence medical records, right?
Yes, Your
His
Honor.
medical records, he testifies to it too. And then you've got evidence of medications that he's on. He comes in, his statement is he's on drugs. It appears he's in possession of drugs. That's why he's arrested for it. He's got a long history of substance abuse, long history of mental illness. I'm not really clear how an expert who's saying the consensus of the scientific community is that mental illness is a factor associated with false confessions. And why, if the people's position is, well, we don't know how that affected him specifically, that isn't something that gets resolved at trial, as opposed to that general science when he has put forward medical records and his own testimony about his condition at the time. And of course, the detective the first day is talking about what appears to him to be somewhat erratic, perhaps drug-induced behavior, who knows.
Your Honor, if I could answer that in two parts. First, related to the timing and the circumstances of the interrogation, it's important to note that this defendant was brought into the precinct first on the night of March 1st. And at that point, even the detective admitted he was in a bit more of an agitated state. He was not willing to speak at that time. He did sign the Miranda sheet and agree to speak with the detectives, but really didn't get into anything substantive at that point. According to Detective Grinder, that is the night when he was asking for his medication, which the detective did testify he went and picked up from the defendant's friend. At that point, at the end of the night, the defendant is sent back to central booking, where he stays for more than 8 hours. And it's not until the next morning, March 2nd, when he's brought back to the precinct somewhere around 9:30, that he gives that first written statement at 10 o'clock in the morning. And the defendant's own testimony about the circumstances of that statement, he affirms on cross-examination that he was not feeling as he did the night before when he claimed he had a seizure.
So if I'm understanding your argument is there's nothing in the record, including from the defendant, to say at the second day, when you've got the typed up forms, and he makes what the detective says is a verbal account of having committed the crime, the one that's he's on trial for, or was going to be on trial for, that in no way suggests that he's under the influence of any, indicating any of the dispositional factors that the expert was testifying to, despite the long history of mental illness. Is that correct?
Yes, Your Honor, that is
That's your
correct.
position? Okay.
And it's important to note that this relates both to the relevance and the general acceptance point, but for the primary focus of mental illness, which is what the defense has focused most heavily
So
on.
let me ask you this, does that devolve then to your rule being that under Badesi, the only expert who could ever testify is the one who not only has the research background like this particular expert, but also has the clinical experience and interviews and goes through a conversation with the actual defendant? Is that the rule that the people are proposing?
No, Your Honor, it is not. And I disagree with the defense's characterization that the judge was imputing some type of personal knowledge requirement here. Ultimately, the issue was that this expert could not establish that the particular principles about which she was going to testify were generally accepted in the scientific community. And it's important to make that distinction between the general science and the phenomenon of false confessions, as opposed to the specific situational and dispositional risk factors about what she was proposing to testify. And that's why this is most analogous to the line of cases with identification expert testimony, because each of those factors, like weapon focus, has cross-racial identification. They've had to withstand numerous Fry hearings.
But let me ask you this, if you're correct about the record and the way the court views the record, then why would the court say, as I understand it twice, just get me an expert who is able to, for lack of a better way of saying it, connect the dots, but to establish that indeed their testimony will be relevant? Because if you're right, no one could ever do that, right? If in the moment he is not in any way expressing any of these dispositional characteristics, no expert could ever walk in the door and testify to that.
Well, Your Honor, I disagree with that, in that there would be circumstances when those factors would be specifically relevant to a particular defendant and interrogation. And I think that what the trial court was getting at is that the defendant could have called Dr. Drobe, who was the clinical psychologist in this case, and it would not have been to testify about false confessions generally, but to testify about this particular defendant and his history of mental illness, his history of medication.
But if he did that, why then couldn't the defense counsel then call Dr. Redlick to then have that further information specific, as you say, specific about false confessions that would allow the jury to then make the determination solely within the province of the jury whether or not they believe that in this case, based on the evidence presented, hearing the experts, that they've decided, no, there's no false confession here. Or yes, there was a false confession here.
It would still not have been appropriate to allow Dr. Redlick to testify, even if Dr. Drobe had testified, because Dr. Drobe was in the unique position of being able to testify that this defendant with this history would have been experiencing certain symptoms or side effects as a result of not having taken his medication for X number of hours. That doesn't cure the problems with Dr. Redlick's testimony, and that comes back to general acceptance. So to have Dr. Redlick...
Can you specify what were the problems with her testimony? Was it that she didn't testify that the specific kinds of mental illness that he had would have made him more suggestible to or amenable to false confession? Or what exactly is it that you're saying is missing? Let's assume that Dr. Drobe had testified to what his particular circumstances were, the kinds of mental illnesses he had, what kinds of medications he was on, whatever. What was then missing from Dr. Redlick's testimony that would have put the two together?
What was missing, Your Honor, is that the specific dispositional factors and situational factors that she proposed to testify about, showing that those were generally accepted within the scientific community.
Give me an example.
When we look at her discussion of mental illness, which is primarily what she focused on, she's really impeached by her own testimony and her own words in the studies proffered as part of the defense papers at the Fry hearing. In the 2010 study that she did about self-reported false confessions among people with mental illness, she actually says, this is Dr. Redlick's study, that those findings should not be used as evidence that mental illness increases susceptibility to making false statements against oneself. And that's only a few years before she gets up at the Fry hearing and proposes to testify to that very principle before a jury. So to have Dr. Redlick testify to a principle like that at trial and show as if it had been well-studied or well-established, that improperly invades the province of the
What
jury.
about all the scientific studies that were also entered at the Fry hearing? Are you saying those don't establish that mental illness is generally considered by the relevant scientific community as a factor associated with false confessions? And I don't read the record the way you do about her testimony, but let's just stay with the other scientific. There was a lot of scientific information and literature that was submitted, right?
There were several pieces of literature introduced at the hearing. A few of
Including
them
the
were-
white paper, correct?
Yes, there was a white paper, Your Honor, but that was not sufficient to show at that time that the particular principles were established as generally accepted. And a white paper alone, some of that, in terms of who sponsored it and what the white paper discussed, is actually just letting the community know what are these topics that are being researched by the relevant.
So clarify for me, is it your position then that an expert, given what the court had said, that if defense counsel brought in another expert that had used different studies, that the expert didn't say those were old kinds of studies, they've been critiqued, they're not really used so much now, but said these are the studies we're using now, and had said that the same documents are submitted on the scientific literature, and had said there's a general consensus, that would have been acceptable?
No, Your Honor, I don't believe so. And at the time this is
So then,
submitted.
full stop, the people's position is that when this hearing was held, and I think it's 2014, 2 years more or less after Badesi, the science was not there.
Yes, Your Honor, that the science regarding the specific principles, not the phenomenon of false confessions generally, the people are not contesting that, but that the science regarding these specific principles was not there. Dr. Redlick was a qualified expert in her field. She was clearly one of the leading researchers looking at these specific factors. But in her own words, she says that the studies aren't there yet. She says there needs to be comparable data from those without mental illnesses. We need to look more into
Is
true
the
versus
people's
false.
position the science is not there now?
Your Honor, that would have to be a decision for another court to make at another Fry hearing. And again, it would have to look at the specific principles. And it's important not to just group this as what is the testimony about false confessions generally, but to go through each and every factor, just like
I'm
this
struggling, though.
court-
It sounds to me like you're saying that the phenomenon of false confession is not scientifically valid.
I would disagree with that, Your Honor, in that
Tell me, what are you saying? What is your position on false confessions?
our position would be that false confessions do and can occur. And in terms of the specific factors that might lead to that, there needs to be further research done on that. The alt-key study and the cheating paradigm that are brought up by Dr. Redlick, those were the initial laboratory-type methods used, and those have been found to be unreliable or inapplicable. So it seems that the research has moved more into these self-reporting studies, and I'm not contesting that self-reporting can be a legitimate means of testing the reliability and assessing general acceptance, but it is one factor to consider given the very limited body of research that is available and that was
Well,
available.
That, of course, would be something that a trier of fact would weigh, but you're not saying before us that you don't believe false confessions take place.
I am not saying that, Your Honor.
Thank you, counsel.
I'm sorry, may I just ask one, 'cause I know you can't come back. So let me just ask, given what you've just said, what are we to understand of the language in Badesi, and it's in 2 different paragraphs, I'm going to quote it. Research in the area of false confessions purports to show that certain types of defendants are more likely to be coerced into giving a false confession. Example, individuals are highly compliant or intellectually impaired, or suffer from a diagnosable psychiatric disorder, who are for some other reason psychologically or mentally fragile, and then quotes some research on that. And then the next paragraph, research also purports to identify certain conditions or characteristics of an interrogation which might induce someone to confess falsely to a crime, and that's discussing situational factors. What are we to make of that language? If the science isn't there in 2014, so it's not going to be there in 2012, what are we to make of this kind of language?
Your Honor, I think what's key in that language is Badesi's discussion of what the research purports to show. The research is getting there, and that's why LeGrand is a helpful case to use and analogous to this circumstance, because in that case, the court found that 3 out of the 4 factors proposed by the defense regarding expert identification.
But then why does, I believe it's Judge Reed, close the discussion with, and there is no doubt that experts in such disciplines as psychiatry and psychology or the social sciences may offer valuable testimony to educate a jury about those factors of personality and situation that the relevant scientific community considers to be associated with false confessions. She must be referring to the factors she's already listed, otherwise it makes no sense in context.
Your Honor, I think that should be read as that those are the factors being researched in the scientific community, and saying that the testimony could be valuable does not mean that the testimony about each and every one of those factors has been deemed to be generally accepted. And when you take that and the general acceptance idea together with the relevance issue in this case, where the Reed method was such a significant part of what this expert proposed to testify about, she had no indication of whether or not those specific methods were used in this case. She talks almost exclusively about this idea of minimization and how that's consistent, but there's 2 issues with that, because in her own study, the 2011 study where she compares true and false confessions, which she says was only the 2nd study done at the time comparing those 2, she says because minimization is so common, its utility to distinguish between true and false confessions may be of limited value. So here, when we look closely at the interrogation and the defendant that were before this trial court, he was absolutely within his discretion to preclude this expert's testimony. If I could just briefly, Your Honor, address the harmless error issue that several of Your Honors brought up before. Here, the video surveillance is one aspect of what corroborates the eyewitness's testimony as well as the confession, but it's important to look at what that video surveillance actually showed. The victim testified that she initially encountered the defendant outside a grocery store just down the block from her apartment building. She sees him briefly there and is within 2 feet of him, she testifies. Ultimately, she then goes back to her apartment where the robbery occurs in the elevator, which is almost 3 full minutes long. And although that video does not clearly depict the defendant's face at any point, it shows that Ms. Yan, the victim in that case, had a significant opportunity to view the defendant, so that when she ultimately makes an identification of him...
Isn't that the whole point? That's what the expert might have helped the jury understand, that merely having that kind of vantage point under all the other circumstances might not make it so obvious that it's an accurate identification. Isn't that the point?
No, Your Honor, and the trial court was absolutely within his discretion to preclude both the identification expert and the false confession expert. And I would just conclude by saying that this court has repeatedly gone against bright-line rules, and with this court's decision in People versus McCullough, it specifically rejected that bright-line rule with respect to identification experts. So I would ask that this court find that the trial court was within his discretion to preclude both the false confession expert testimony and the identification expert testimony. Thank you.
Thank you. Counsel, you have your 2 minutes rebuttal time.
Thank you, Your Honor.
Well, counsel, why isn't she correct that the real problem is that the expert is testifying to situational dispositional factors, talking about the literature, et cetera, but herself says that there's real problem in the methodology that she herself has used? Why aren't the people correct about that? That's what really makes her the wrong expert for this kind of testimony.
Your Honor, I think candid discussion of scientific progress and about revising hypotheses and about the evolving nature of science actually makes her a more credible expert. And I think the people really are glossing over the fact that there were numerous articles entered into evidence that even if they quibble with Dr. Redlick, they are certainly free to do that before a jury, but here the jury didn't get it because the judge believed this cross-examination that was given of Dr. Redlick, decided the science wasn't there, and did not allow the jury to have it. In fact, these quibbles with her previous research, or, maybe you've backtracked on this hypothesis, doctor, that would have been great before a jury. And so the people's argument really is suited for that, for trial, not for a Fry hearing. I also would note that people did not present an expert. There was no expert here.
Did any of the scientific literature that was admitted at the Fry hearing, did any of it suggest uncertainty within the scientific community about situational, dispositional factors, that it put any of them in some,
Yeah.
a box? We're not sure, we think, but we're still doing research on this.
Yes, I mean, having perused all the literature that was entered, much of it was quite candid about what was not. For example, as to the mental illness issue, the question was which particular diagnosis might predispose someone. So I would refer your honors and the white papers to 584 to 85 of the appendix. There, the question was the diagnosis, but recent research had shown that depression, of which my client suffered, had a correlation to it. If the court is inclined to throw out some of these factors, if the court actually is inclined to, I just would point to the fact that the cognitive impairment is widely established, it has been established by the Supreme Court, by this court, it is widely acknowledged as a mental retardation in older parlance, is widely established as linked to false confession, and in addition, lengthy interrogations. And if the court would like references to the articles, I would.
Why didn't defendant offer any evidence about the particular interrogation techniques used by the NYPD and the training that they had and so forth and so on? Wouldn't that have possibly helped?
Well, Your Honor, I mean, he tried to during the suppression hearing, and the detective clammed up and said, I've never been trained in interrogation, I don't remember what I asked. So, I mean, that was the only basis that he had of finding out.
Well, but couldn't they have brought in other witnesses to testify? Superiors in the department, here's the training that we give our police officers and so on and so forth?
Certainly he could have. I don't think it was necessary here, Your Honor, given that there was evidence in my client's statement itself as to the possibility of minimization. That said, if the court doesn't find that situational factors are present here, aside from the lengthy interrogation, which is an acknowledged situation.
Yeah, you refer to lengthy interrogation, but how long was the interrogation? We're talking about from the time he was arrested to the time he made his statement, even though he was only in the interrogation or the interview room and discussing this for what sounds like about maybe an hour, if that?
He was interrogated 3 times over the course of about 24 hours. He was arrested at 2 o'clock. He was Mirandized, according to the detective at the suppression hearing, at 6:30, although this was impeached at trial, that the Miranda happened at that time at all.
So when we look at the duration of the interrogation, we look from the time they brought him in to the time he went home, regardless of whether he slept, regardless of whether he was in the same room, regardless of whether he ate. Is that
Well, I would point your honor to the white paper page, appendix page 579. Part of this is the custody and the isolation, the actual removal of somebody. So yes, he was interrogated intermittently. He certainly wasn't interrogated for 24 hours. That would be outrageous of me to say that. But but I would point the court to page 579, in which it discusses this technique of isolating someone for a lengthy period of time.
Thank you,
So
counsel.
if the court has any further questions? I know we've taken up a lot of your time.
The
Thank
court
you.
will stand in a 10-minute recess.